Hi, everyone. Dave Sugden of Evidence at Trial. Let's talk about the 5-second rule for lawyers. What am I talking about? Let me first talk about first responders. Whenever there's a person who's unresponsive, first responders have this mnemonic device, ABCs, so they can identify the priorities when dealing with someone. It's air, breathing, circulation. Pilots, where there's an engine failure, have the same thing, and it's the ABCDE priority. And why do they have this? It's so that in these stressful moments, they're able to have a methodology so they can prioritize the needs. Now, I know it's a little much for me to compare a civil trial moment compared to first responders and pilots dealing with a failed engine, but stick with me, because any trial lawyer has had that moment where a line of questioning begins or a document's going to be introduced and we know intuitively we don't want it in and it shouldn't be in. But in that stressful moment, it can be hard to quickly and accurately identify the required objection. So what do? We need a mnemonic, because without that, we may simply say objection, and other than thinking this really hurts our case, we can't identify it. And so here's a graphic that identifies the priority or hierarchy of issues we want to identify when confronting a potential objection. And it's relevance, foundation, hearsay, exclusions and limitations, prejudice, and form of the question. And if we need a mnemonic, it's really funny horses eat peanuts fast. But again, in trial, just having this cheat sheet that shows this graphic can get us almost all the way. Now, what we're going to do in this video is identify a way where we can contemplate relevance, foundation, hearsay in seconds, because as we know, all of these rules take some time. Take hearsay, for example. It has a general rule of exclusion followed by a number of exceptions. So how can we identify it in just a matter of seconds? And it's a matter of seconds that we have to be both fast and accurate, because we have to, in 1 or 2 seconds, state the objection, and then maybe 1 or 2 seconds later, state the grounds. So the first thing we want to look at is relevance. And how do we quickly analyze whether something is relevant? Again, we go to the statutes. And so in the federal rules, it's Rule 401. In California, it's Section 210. And they both, in essence, say the same thing. And for our purposes, when we're just in trial, just think of this rule is, as this line of questioning begins, we ask ourselves, does this lead to any evidence that has a tendency in reason to prove a disputed fact that's of consequence to the action? And so we want to just think of this as 2 parts. 1, does this have a tendency in reason to prove something? Does it advance the ball? 2nd, is it a disputed fact of consequence to the action? What does that mean? In other words, is this an issue framed by the pleadings? And this shows the importance of knowing the complaint and the answer and any operative pleadings, because when you make that relevance objection, you have to say objection, relevance, and be ready to explain why. And when you do that, make sure that you sort of use the language of the statute, where you say something to the effect of, Your Honor, this lawyer is starting to ask about X, Y, and Z. That does not have a tendency and reason to prove anything of consequence to the action, because X, Y, and Z isn't raised by the pleadings. Just frame the issue in a way that mirrors the statute and do it quickly. Next, we have foundation. What does that mean? Now, when it talks about foundation for witness testimony, we're asking ourselves, does this witness have personal knowledge about what he or she is talking about? In other words, if there's a witness who's being asked about X, Y, and Z, has it been established how the witness knows that X, Y, and Z exist or are true or anything to that effect? And so unless there's been a foundation laid, unless there's been questions that establish how a witness knows something, that's the objection. If it's a document, we want to ask ourselves, has the proponent of the evidence, our opponent in this case, provided sufficient evidence to establish a likelihood that the document is what the proponent claims it to be? In other words, rather than just getting this document into evidence, has there been a foundation laid? Next, hearsay. Now, this can be a tricky one because, as we know, there's the hearsay rule followed by a ton of exceptions. And so how do we, in a matter of seconds, identify objectionable hearsay? So from law school, we all recall the definition of the hearsay rule, which is an out-of-court statement by a declarant that's offered to prove the truth of the matter asserted. In the heat of trial, not that helpful. It's a bit of a mouthful. So how do we attack it quickly? Two pieces. One, we ask, why is this statement being offered? And this is the for the truth of the matter asserted. And so a shorthand way to consider that is this statement being offered to prove what the statement says? For example, if the testimony is going to be, John Doe witness said, it is raining. If that statement, it is raining, is being offered to prove it is raining, we have hearsay. And so quickly ask yourself, with respect to this statement, is there a match between the statement itself and why it's being offered? If there's a match, it's hearsay. Now, how do we know if it's objectionable hearsay? Because there are so many exceptions. A shorthand way of knowing hearsay exceptions is to understand why the exceptions exist. There's essentially two reasons why a hearsay exception exists. One, the out-of-court statement is very trustworthy. The other reason, for example, a business record. If you can establish that this is a business record, the law in essence says this is a trustworthy document, it's going to be admitted. The other reason for an exception to exist is it's necessary. In other words, the document may be really old. It could be a 30-year-old deed, and there's obviously no witness around in a convenient way to attest to the statement. And so the law essentially says this is necessary. We're going to have an exception. And so if it's any combination of the two, necessary or trustworthy, an exception may exist. Now, how do we then, knowing that's the general rule for exceptions, how can we quickly spot objectionable hearsay? And a working rule can be, when you hear that statement, you ask yourselves, does the probative value of that testimony turn on someone who can't be cross-examined? In other words, going back to our "it is raining" statement, if that was a big deal in the case, and the probative value of that statement, whether or not it was raining, turned on the credibility of an out-of-court declarant, this John Doe witness, who can't be cross-examined, and you'd want to cross-examine that witness, it's a good chance there's a objectionable hearsay moment, and you lodge that hearsay objection. Next, exclusions and limitations. What are we talking about? We're talking about privileges, privacy, character evidence. And so when we're talking about privileges, attorney-client, patient-doctor privileges, there's a host. Privacy, is there a line of questions going to invade the witness or one of the parties' privacy rights? Those are issues we want to identify quickly. When it comes to character evidence, I would encourage you, and we'll have a link in the description below, go to my video on character evidence, because it's similar to hearsay in the sense that there's a general rule of exclusion followed by exceptions, but the added wrinkle is that with respect to character evidence, the reason why it may be admitted turns on the type of evidence that may be allowed. So go check out that video to understand quickly character evidence. Next, we have prejudice. And so what are we talking about here? We're talking about evidence that is relevant, but for some reason it is substantially outweighed by the prejudice of the evidence. In other words, it's too prejudicial to the party. It could create an undue consumption of time. It could be confusing for the jury. Now, in California, we're talking about Section 352 of the Evidence Code, and in the federal rules, we're talking about 403. The reason those numbers are important is that when you make the objection based on prejudice, here's the numbers, okay? So going back to relevance, for example, when you object on relevance, you don't have to say, for example, objection 210 in California or objection 401 in federal court. You can simply say objection relevance. But when it comes to prejudice, you do want to use the numbers. And the reason why is because you don't want to object in front of the jury and say, "Objection, Your Honor, this evidence is just too prejudicial to my side." You don't want to say that. And so instead, you want to say in California State Court, Objection 352 or Objection 403 if you're in federal court. Finally, let's talk about the form of the question. And this is an objection that we'll often make in depositions to make sure that we have a clean record. On the other hand, in trial, this is the last thing we want to consider. Because number one, if the question is vague, for example, it won't matter because the jury won't understand the question or the answer. And so if you make an objection based on vagueness or the question's compound, it can be easily fixed. And so what you may be doing is giving your opposing counsel a chance to ask a better question and get a better answer, which could be worse for your case. So there it is: relevance, foundation, hearsay, exclusions, limitations, prejudice, form of the question. That's the 5-second rule for lawyers in trial. Folks, I hope this was helpful. If it was, please like, subscribe. We keep putting out these videos to provide trial lawyers with tools they can use in trial. If you want to do a really deep dive on these topics and these strategies, check out evidenceattrial.com. Thanks for watching.